Welcome. My name is Barbara Griffin. I am president of the League of Women Voters of the Charleston area, and I have the honor of moderating tonight's event and the privilege of welcoming you. Thank you for taking time out of your busy schedules to join us for what is the fourth event of our five-part series focused on good government. Tonight's event will be all about money in politics. As you likely know by now, no virtual meeting can begin without a few housekeeping reminders, and tonight's event is no different. So please, unless speaking, we ask that you keep your microphones muted to help avoid those unwanted distractions. And also we ask that you turn off your video cameras in order for us to be able to focus on our speakers. We expect to have time for questions at the end. And we encourage you to submit your questions via chat to the host. We are live streaming on our League Facebook page, and the recording should be available when we're finished with this evening's event. The video will also be available on YouTube and on the League's website. We want to take this moment next, Leslie. And next, we want to take this moment, an opportunity to thank our many collaborators from across the state. They naturally include the League of Women Voters of South Carolina, but also local leagues from Clemson, Columbia, Florence, Greenville, Hilton Head Island, Bluffton, and Spartanburg. In addition to our league support, we also have collaborators from the College of Charleston's Political Science Department, Women in Leadership, the NAACP Legal Defense Fund, the South Carolina Interfaith Power and Light and Sustaining Way, the ACLU of South Carolina, the South Carolina Commission for Minority Affairs, and the Buckley Chamber of Commerce. And also let's give a shout out to the organizing team, Barbara Zia, Shana Howell, Sarah Johnson, Kirsten Abramson, Leslie Scarden, Leah Pedersen, and others. So just a few words about our Good Governance series. This five-part nonpartisan series is intended to promote education and awareness relating to critical good government issues that impact us at the national, state, and local levels. Recordings of all of the events can be accessed via Facebook or YouTube. Pre-reads were shared with all event invitations for those who are interested in gaining additional insights and perspectives. We've shared calls to action with each of our event series, and we believe tonight's call to action will be both engaging and educational. Please go to our website and sign up for our newsletter to get more information on the next session and other information about League events and activities. Okay. Our upcoming and final event for this year will be focused on election and voting systems and approaches, and is tentatively set for Monday, June 7th, so it's right around the corner. We hope you will join us. Tonight, we will focus on the impact of money in politics, all of its ramifications and implications. And we are blessed to have two featured speakers who come to us with credentials, experience, and I think a bit of wisdom. They are Patrick Llewellyn from the Campaign Legal Center and former Senator, South Carolina State Senator Larry Martin. Mr. Llewellyn will speak first. By way of introduction, Patrick Llewellyn is the Director of Campaign Finance at the Campaign Legal Center, which you will hear referred to as the CLC. Mr. Llewellyn directs the CLC's work with state and local stakeholders and policymakers to advance innovative policies and strategies designed to decrease the adverse impact of the influence of money in our political processes. Prior to joining the CLC, he worked as an attorney at Public Citizen Litigation Group, where his practice focused on government transparency, and he represented nonpartisan, not-for-profit organizations, journalists, and researchers about federal court issues. He also has served as a staff attorney and teaching fellow in the Civil Rights Clinic at Georgetown University, but he is a graduate of Harvard Law School. Let me introduce to you Mr. Llewellyn. Thank you.
Thank you so much for that introduction, Barbara. And I'm excited and honored to be speaking with you all this evening about campaign finance reform and money in politics. In our federal, state, and local elections, we all too often see a system that works for wealthy special interests to handpick their preferred candidates and policies, and not one in which most people from all parts of our communities can make their voices heard. And there's several meaningful solutions to the problems that we face, but before we talk about those, it's important to understand the field we're playing on and how we got here. So to do that, I'm going to start my presentation by going through a handful of major legal changes at the national level over the last 50 years or so, and we'll then talk about where that leaves us and some ways forward. We'll have a Q&A at the end, and I'd be happy to take any questions at that time. Next slide, please. Now, before diving in, I thought it would be helpful to introduce at a high level what the rules of the game are, so you can keep them in mind as I talk about how we got here. So contributions, that is money given to candidates, political parties, or groups that give to candidates, can generally be limited, subject to some caveats. Expenditures, that is money spent to influence elections, cannot be limited, save for in a few circumstances. Robust disclosure requirements for those spending money to influence elections have been repeatedly and broadly upheld. And public financing is a viable alternative, provided that it's voluntary and does not penalize non-participants. As I go through, I'll be using some common terms in the campaign finance context, and I'll do my best to define them and explain what I mean when I say them, so we can have a common language that we can use when we talk about these issues. So with that, let's dive in. Next question, or next slide, please. In getting started, the modern system of campaign finance in the US really begins with the Federal Election Campaign Act, or Fica, as I'll call it. Next slide, please. Fica was originally passed in 1971 and made effective in 1972, but the original bill lacked teeth and was largely ineffective. And as most of you know, 1972 was a big year in American politics for another reason, the Watergate scandal. Among the various illegalities involved there, unsurprisingly, were numerous campaign finance abuses, including already illegal corporate campaign contributions and outright bribery. So in response, Congress enacted broad amendments to Fica in 1974 to overhaul the federal campaign finance system and address the scourge of corruption. Next slide, please. Fica had several parts, but among them, the most important when enacted were contribution limits, that is, limits on the amount of money a person could give for election purposes. For example, if you give $50 to a candidate you support, that is a contribution. Fica also had expenditure limits, which is limits on the amount of money a person could spend for election purposes. So if instead of giving money to a candidate, you bought a TV ad that said, vote for this candidate, that would be an expenditure. Fica also created the Federal Election Commission, or the FEC, to enforce the law, and it established a public financing program for presidential elections. Fica also built on some existing campaign finance laws, including corporate and union contribution and expenditure bans that have been in place for decades, and expanded existing disclosure requirements for political spending. In thinking about Fica and campaign finance laws generally, in particular the scope of the law with all of its interconnected parts, it might be helpful to think of it like a house. The law contains several different pieces and definitions that were all meant to work together, like the walls, roof, and support beams of a home. Now you can change the shutters and the curtains and the carpet, but once you start changing the structural elements, there can be serious consequences, which is what we see with Fica. Next slide, please. And that takes us to Buckley versus Vallejo, which many of you have likely heard of, and was a broad constitutional challenge to several of Fica's provisions. Now, just as Fica is the starting point for our modern campaign finance system, Buckley is the foundational case for modern campaign finance jurisprudence, or the case law that governs this area. Now, Buckley is a rich and detailed decision, so I can't possibly cover all of it. But starting off, it's important to understand two key analytical moves made by the Supreme Court in this case. First, the Supreme Court directly connected spending of money for election purposes with political speech. In other words, the court concluded that limits on spending money for election purposes is not a limit on how a person speaks, but instead more like a direct limit on a person's ability to speak. And second, flowing from that, the court distinguished between contributions and expenditures from a constitutional perspective. Although Fica treated them as largely two sides of the same coin, the court concluded contributions were less directly connected with speech than expenditures, meaning the government could more easily justify limiting contributions. And so what did the court do? Well, it upheld some provisions, struck down others, and in the process rewrote the statute. So I'd like to walk through a couple of specific points because it will help introduce terms that are often used in campaign finance law, and it'll also lay the foundation for things to come. Next slide, please. So first, contribution limits were upheld. The court held that contribution limits were justified by the government's interest in preventing corruption and the appearance of corruption. But expenditure limits were struck down. And part of the court's reasoning in this process was it first looked at the word expenditure and redefined what that word meant. Fica had defined the word to mean essentially spending money relative to a federal candidate, which the court decided was too vague, so it redefined the term to mean communications that what it called expressly advocate the election or defeat of a candidate, meaning that the communication had to use words like elect or defeat. This was a big deal because it significantly narrowed what Fica covered. While the law originally intended to cover all spending related to federal elections, it was now limited to very particular election ads in many circumstances. And because the court had determined that limits on spending money for election purposes was like a direct limitation on speech, the court said the government needed a very strong reason to do so and concluded it had not shown enough support for these limits. So the court struck down both campaign expenditure limits, that is limits on how much a candidate's own campaign could spend, and limits on what it called independent expenditures. That is limits on the spending of those outside of the campaign to support or oppose a candidate. It's also important to know that in part of the court's reasoning, it rejected one of the government's arguments, which specifically was that the government attempted to argue to justify the expenditure limits that they were necessary to equalize voices in elections. That is, to ensure that the wealthy did not have excessive influence over the outcome of elections. The court rejected this basis and said, in its words, equalizing voices was wholly foreign to what the First Amendment allowed, and therefore was not a permissible basis for expenditure limits. Next slide, please. But there was an important distinction in the court's decision about expenditures. It differentiated between what it called coordinated expenditures and independent expenditures. Fica treated coordinated expenditures, that is, expenditures that were coordinated with the candidate or made with the candidate's consent or cooperation, as contributions to the candidate. The court agreed. In striking down independent expenditures, in striking down limits on independent expenditures, the court explained that it was because these limits were what it called totally independent from a candidate. And the upshot was that that meant expenditures that were coordinated with a candidate could be treated like contributions and therefore limited. Next slide, please. The court also upheld Fica's disclosure requirements, finding that these disclosure requirements were justified by the government's interest in preventing corruption and its appearance, identifying campaign finance violations, and providing information to the public about who was spending money to influence their elections. The court noted that there was a very narrow exception potentially available to certain groups that face serious threats of retaliation or harm, particularly from the state, but the court rejected any attempt to apply any sort of broad exemption from disclosure requirements. Now, in upholding these disclosure requirements, the court also redefined another important term, and that's political committees, which you might also know as PACs. Originally, Fica defined political committees based on certain thresholds of contributions and expenditures. In other words, Fica provided that if a group received a certain amount of contributions or made expenditures exceeding a certain amount, that group was now a political committee that was required to register with the FEC and file periodic disclosure reports. But the court was concerned this would end up covering too many groups and was too broad, so it again narrowed the definition, this time to only cover groups with what it called a major purpose of influencing federal elections. Again, this was a significant change. Originally, crossing these spending thresholds meant all sorts of groups would be subject to disclosure requirements, but the limited definition again significantly narrowed who was covered. This is sometimes called the major purpose test, and it's often used as a dividing line in how different groups are regulated for campaign finance purposes. Next slide, please. Lastly, the court upheld the Presidential Public Financing Program, and the program had two parts. For the primaries, there were thresholds for qualifications, matching funds for small contributions, and expenditure limits. And for the general election, there was a full grant, an outright ban on private contributions, and an expenditure limit in the sense that the candidates were limited to spending the grant. The court concluded that the voluntary program was constitutional and justified by the government's interest in, and I've put them on the slide because they're a bit wordy, but the government's interest in reducing the deleterious influence of large contributions on the political process, facilitating communication by candidates with the electorate, and freeing candidates from the rigors of fundraising. But again, it's important to remember that the voluntariness of the program was key to it being upheld, because the court allowed certain restrictions in this context that are normally impermissible. So Fica and Buckley set the stage for the development of campaign finance law in the ensuing decades. And as you can see, some parts of the House, so to speak, have already been a bit compromised. I won't spend as much time on or even cover all of the developments between now and then, but there's a few additional pieces to the puzzle that are worth discussing. Next slide, please. So following Fica, the biggest revamp of our federal campaign finance system came in the early 2000s with the Bipartisan Campaign Reform Act of 2002, also called BICRA or sometimes McCain-Feingold because of its two chief sponsors. Next slide, please. And there were two significant developments in the 80s and really the 90s that drove the need for federal reform. First was the explosion of so-called soft money. And this was money that the national political parties were allowed to raise outside of the applicable contribution limits. Because Fica speaks in terms of federal candidates and federal elections, it had been interpreted to not apply to national parties' state and local fundraising. And over time, the parties were allowed to spend that money on mixed federal and state activities, meaning if something promoted both federal and state candidates, the parties were sometimes allowed to use unlimited soft money. Second, sham issue ads pervaded elections. And these were ads that you're all familiar with. They talk about all the negative things a candidate has done or voted for from the advertiser's perspective. And then, rather than say, vote against Jane Smith, the ads say, call Jane Smith's office to let her know what you think. These ads were specifically designed to avoid expressly advocating for candidates. Because remember, the Supreme Court had limited what the word expenditure meant to only cover express advocacy. So because of that, these ads were designed to avoid being express advocacy and therefore required to abide by the disclosure requirements that came with express advocacy. The Senate engaged in a multi-year investigation leading to an impressive legislative record documenting these and other problems that formed the basis for BICRA. Next slide, please. So what did BICRA do? Well, among other things, it got rid of soft money at the federal level by not only barring national political parties from accepting any money outside of federal contribution limits, but also by prohibiting parties, their agents, and federal candidates from soliciting contributions that failed to comply with federal limits, meaning that just because the parties were now barred from taking soft money, they couldn't turn around and tell big donors where to give that money instead to avoid the contribution limits. BICRA also added a new term to the campaign finance lexicon with electioneering communications. And that's defined as ads that reference a federal candidate, that run within a particular time before an election, and that are in specific media, broadcast television or radio. Importantly, electioneering communications do not depend on whether the ads expressly advocate for or against a candidate, and instead reflect the reality that ads can influence elections even while avoiding certain magic words. And by adding electioneering communications, BICRA did two things. First, it applied new disclosure requirements for these types of ads, just like express advocacy. Second, BICRA expanded the corporate expenditure ban to include electioneering communications. Next slide, please. Unsurprisingly, there was a broad constitutional challenge brought against basically every aspect of BICRA, which one of the lead challengers being none other than Senator Mitch McConnell, which is why the case is named McConnell versus FEC. Like Buckley, the opinion in McConnell is rich and detailed, so I won't even cover most of it. But on the whole, the court largely upheld BICRA with a few exceptions. On the issues I've already flagged, first, the soft money ban was upheld. And importantly, the court used a functional analysis. So even though the ban technically prohibited national parties from spending soft money, the court concluded the ban was much more akin to a contribution limit, and thus upheld it based on the government's interest in preventing corruption and the appearance of corruption, and the extensive legislative record documenting the problems with huge, unlimited soft money contributions. Next slide, please. Second, the court upheld the new disclosure requirements for electioneering communications. It explicitly rejected the argument that the government can only require disclosure for express advocacy, and reiterated that the same government interests that support other disclosure requirements support these, with those being preventing corruption, identifying violations of the law, and providing information to the public. And the court also upheld the ban on corporate electioneering communications. And this piece is worth just a bit more background to explain how it really worked. So I've said a couple of times now, and will repeat for brevity, that the law barred corporate expenditures, but that's a bit inaccurate. The law banned corporations from spending, essentially, their profits on expenditures, or what we sometimes call general treasury funds. But the law allowed, and continues to allow, corporations to set up their own PACs. These PACs are funded by voluntary contributions, usually employers or stockholders or other people connected to the corporation, and not business money. So although these PACs can be controlled by the corporation and used to make both contributions and expenditures, they do not allow the corporation to put the money it receives from its profits into the political process. So this provision of BICRA simply expanded it. While previously, corporations could use general treasury funds to pay for what were now called electioneering communications, this required that they use their PACs instead. In building on prior case law, the court reiterated that the government's interest in preventing corruption, in particular, what it called the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas, justified the expanded ban. So that covers the major enacted federal legislation in recent history. And of course, we have HR 1 and S1 still pending, and we'll talk about that a bit later. But now I want to briefly talk about one more recent decision by the Supreme Court that more clearly illustrates the limits of our current campaign finance landscape. Next slide, please. And that's the infamous Citizens United case, which I'm sure you've heard of. And as you might expect, the court's decision in this case has important implications for thinking about campaign finance solutions. Next slide, please. So turning to the case itself, it was a constitutional challenge to the corporate expenditure ban, which, as I just explained, was really a ban on corporations using their business money for expenditures. And as I said before, this was part of the law well before Fica. In 1907, Congress first banned corporate contributions to candidates, and in 1947, expanded the ban to both encompass unions and to ban corporate and union expenditures. The court upheld a similar state corporate expenditure ban in 1990 in a case called Austin versus Michigan Chamber of Commerce. And as we just talked about, the court upheld in McConnell an expansion of the corporate expenditure ban to include electioneering communications just 7 years prior to Citizens United. It's also worth noting that this case was a reach by the Supreme Court. The case had not been litigated as what's called a facial challenge, that is, a challenge to the law in every application, and instead had focused only on the law's application to the particular nonprofit in the case. But while the case was pending before the Supreme Court, it converted it to a facial challenge. Next slide, please. So what happened? Well, as you might already know, the court struck down the ban on independent expenditures and electioneering communications by corporations. And two key parts of its analysis continue to govern campaign finance law today. So first, the court limited the permissible government interest in preventing corruption for campaign finance laws to preventing what it called quid pro quo corruption. Quid pro quo literally means something for something or this for that. And in the context of corruption, it means outright bribery. Court opinions had previously rejected, even in Mcconnell, such a narrow view of the type of corruption that could justify campaign finance regulations. Remember what I said earlier about the corrosive effect of immense accumulations of wealth through the corporate form? And this is important because by limiting to a very narrow type of corruption that the government can rely on, it narrows what the government can use to support campaign finance laws. And second, following this limitation, the court made a sweeping pronouncement that, quote, independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. This was essentially a binding finding of fact by the Supreme Court, applying a newly announced standard on the basis of an absent factual record. And I'm obviously betraying a bit how I feel about the decision, but it's important to know this background in understanding how big of a change this was when the Supreme Court made this decision. Next slide, please. Importantly, though, the court upholds disclosure requirements for corporate independent expenditures and electioneering communications. The court concludes that these are justified by the need to provide information to the public about the amounts and sources of money being spent to influence elections, and it again rejects limiting disclosure to express advocacy. The court also reiterated the narrowness of any potential exception available to some groups in denying an exception to Citizens United itself. And one thing I always like to remind people is that this part of the decision was 8-1, illustrating the broad support of the constitutionality of meaningful disclosure requirements. Next slide, please. And there's 2 points in the aftermath of Citizens United that are worth knowing as well. So first, in a case decided shortly thereafter by the Federal Court of Appeals in DC, the reasoning of Citizens United was extended to independent expenditure-only political committees. It's a bit of a mouthful, so let me explain what I mean by that. Under federal law, political committees operate somewhat like candidates in the sense that contribution limits apply to the amount of money they can take in, and contribution limits also apply in how much the political committees can give to candidates. So this case involved political committees that did not make any contributions to candidates and instead only wanted to spend their money on independent expenditures. Because Citizens United had broadly pronounced that independent expenditures cannot corrupt, this court held that contributions could not be limited to political committees that make only independent expenditures. Because remember, the only basis permissible for limiting contributions was preventing corruption. This led to the creation of so-called super PACs, which are political committees that make only independent expenditures, and as a result, can take in unlimited money, including from corporate sources. Second, it's important to remember that Citizens United did not affect the corporate contribution ban. The Supreme Court upheld that ban in FEC versus Beaumont in 2003, and both at the federal level and in several states, direct corporate contributions to candidates continue to be barred. Next slide, please. So understanding a bit more about where we are, and in particular what the Supreme Court has said the Constitution allows for and requires, and seeing some of the, I guess, gaps and shaky foundations in the House that remains, that draws into focus the current problems we have and some potential solutions. Next slide, please. So the first problem I want to talk about is dark money. We know, and courts agree, that disclosure of the sources and amounts of money spent to influence elections is a vital tool in shining light on large independent expenditures and informing the public about who is trying to influence their vote. And donor identification for big spenders is key, but it's often circumvented by wealthy special interests through transfers and intermediaries, leading to what we call dark money. For example, let's say I'm a billionaire and I want to run ads supporting my preferred candidate. If I bought those ads myself, in most places, my name would go on the ad. But if instead I run my money through a 501c4 nonprofit or an LLC, in most circumstances, whether the C4 or the LLC spends the money directly or passes it along to the super PAC, the only identity that would be disclosed is the nonprofit or the LLC, leaving the public in the dark about where the money actually came from. Adding to the problem, let's say I name my nonprofit or my LLC South Carolinians for a Better South Carolina. Not only do you not know where the money came from, but you don't know what the aims or the goals of that group are in spending the money. So most laws fall short by leaving out disclosure requirements for non-political committees. That is, not requiring groups like 501c4s or LLCs to make any disclosures, or by only requiring disclosure of direct contributors, which means the identity of the group that directly gives the money, but not tracing any further back to the original source. And from my understanding, South Carolina appears to currently be an extreme case in lack of disclosure, because my understanding is that the law is currently interpreted and enforced to perhaps not even require disclosure by even political committees, leaving only candidates and political parties filing any disclosure whatsoever. Next slide, please. And how big is the problem? Here's a little bit of information to help you understand the scope of what we're dealing with. So secret spending in elections is growing. First, it was just millions, and then tens of millions of dollars. And now, according to the Center for Responsive Politics, over $1 billion in dark money was spent in the 2020 elections. And that includes both direct spending by groups that don't disclose their donors and giving by those groups to super PACs for election spending. And it's a bipartisan problem. In some cycles, Republicans have been supported by more dark money, but in other cycles, including the most recent one in 2020, Democrats have been supported by more dark money. So it's not limited to one group or one type of candidate. Next slide, please. And what's the solution? Robust disclosure. So a comprehensive disclosure law should have several parts, but it should focus on requiring all big spenders to identify the original sources of the money they spend to influence elections. And that means differentiating between people who spend their own money and those who spend transferred money, with transferred money being traced back to the original source. These requirements could also be extended to require identification of original sources on election ads themselves. And as a means of giving donors control over their money, a broad disclosure system could also provide for donor opt-out, allowing donors to opt out of their money being spent for election purposes. Moreover, all election ads should be covered by disclosure requirements. Because we know that ads can influence elections even without magic words, the law should not be limited to express advocacy. And given the ubiquity of the internet and digital communications, effective laws must ensure parity for digital ads. And I don't have a slide on this, but the For the People Act, also known as HR 1 and S1, would address several of these issues by enacting what's called the Disclose Act. And in short, the Disclose Act would work by requiring that every time a person transfers big money that's used for federal election spending, that person would be required to file a report, noting the amount of money, where the money came from, and where it was transferred to. And by requiring reports by every person in the chain, the law would trace money back to its original source. HR 1 would also expand federal disclosure requirements to cover more election ads, including by ensuring that paid internet ads are included as part of the definition of electioneering communications, which they currently are not. Next slide, please. The second problem I'd like to talk about is foreign interference in our elections. And as everyone is likely aware, recent elections have demonstrated the potential for foreign interests to interfere with US elections. Now, federal law already prohibits foreign nationals from making contributions or expenditures to influence federal, state, or local elections, but there's some problems with its coverage. One problem, which may not be a problem statewide for South Carolina, but probably is for some localities, is that the law has been interpreted to only apply to candidate elections, not ballot initiatives or referenda. That means that even a foreign national, otherwise barred by federal law from spending money to influence candidate elections, like a mayor's race, can still spend money to influence ballot initiatives, like, say, a local tax increase that's voted on by the voters. Additionally, the definition of foreign national leaves a significant gap for foreign-controlled corporations. Currently included in the ban are corporations that are formed in another country, but not those that are formed in the United States. Pre-Citizens United, this was less of a problem because all corporations were banned from making expenditures. And just to give you a sense of how broad the problem is, for example, the FEC has interpreted the law to not apply to wholly owned domestic subsidiaries of foreign corporations, meaning that if there's a corporation formed in the US, but wholly owned by another foreign corporation, the ban does not apply so long as only domestic money is used and no other foreign national is involved in the decision making. And I would note that it looks like South Carolina, like several states, lacks a separate state law banning foreign interference. And so these gaps in coverage in the federal law would affect South Carolina elections. Next slide, please. So to help illustrate the problem, I wanted to provide a few examples. First, I think most folks have some familiarity with the reporting on Russian involvement in the 2016 elections, but one study is particularly noteworthy because it found that out of over 100 what it called suspicious advertisers on Facebook, and it defined suspicious advertisers as groups that had little to no information available about them on their Facebook group or elsewhere, but that had bought election ads in 2016 on Facebook, that out of over 100 of those suspicious advertisers, 1/6 were Kremlin-linked groups, which is an incredibly high amount of Russian election ads in the US. Second, from a state perspective, you can look to Maine, where Hydro-Quebec, a Canadian government-owned public utility, spent over $9 million to oppose a ballot initiative in Maine that would have blocked part of one of its power line projects. Next slide, please. So what's the solution? Expand the ban. And by that, I mean treat foreign-controlled corporations the same as other foreign groups by using thresholds of foreign ownership, meaning that if a corporation has a substantial amount of foreign ownership or control, it should be treated like any other foreign corporation. Additionally, the ban should be extended to cover ballot referenda. And HR 1 and S1 would address parts of this problem by expanding federal law to cover state and local ballot referenda explicitly. And the expanded disclosure requirements would also help protect against dark money, because by disclosing the true source of money spent on elections, it can help ensure that foreign money is not finding its way into elections through dark money sources. Next slide, please. And lastly, I want to talk briefly about public financing. Over 30 states and localities have a public financing system of some sort, and I want to make sure to mention that some of the most successful, innovative programs are at the local level. So even if a statewide program isn't feasible at this moment, it may be at the local level. And at a high level, it's important to remember what case law requires. Candidate participation must be voluntary, and some other cases considered by the courts have made clear that the program cannot penalize non-participating candidates or outside groups. There's a few different types of programs, but I think it's really the last two that are the most promising. So first, there are grants, which are the traditional form of public financing, with a candidate receiving a block grant for an election after meeting certain qualifications and agreeing to certain requirements. More recently, though, many places have moved towards what are sometimes called matching funds programs or small donor public financing programs. In this type of system, a qualifying candidate receives a public match for certain small dollar contributions. While originally these programs were set up as 1-to-1 or 2-to-1 matches, most viable programs now utilize larger matches, such as 6-to-1 or 8-to-1, to ensure their effectiveness. And these types of programs are in place in New York City, Berkeley, California, Portland, Oregon, and other places as well. And some places, like Washington, D.C., blend both grants and matching funds. HR 1 would implement a 6-to-1 matching fund program for congressional and presidential elections. So the way that would work is the program would provide $6 for every $1 in contributions received up to $200 per contributor. Participating candidates would agree to, among other things, lower contribution limits, to refuse PAC money except for small donor PACs, and to limit their personal funds used on their race. Now, candidates would qualify by raising at least 1,000 small donations, meaning less than $200, that would total at least $50,000. And the program would be paid for by a surcharge on fines and fees paid to the government by corporate and executive criminal violators. But perhaps the most innovative program is one that's sometimes called democracy dollars or vouchers. Under this system, the government provides eligible people with a credit of public funds or vouchers to assign to candidates of their choice. The only program like this to be adopted so far is in Seattle, and there eligible city residents each receive 4 $25 vouchers each election year, which they may give to multiple candidates or all to one candidate. And the benefit of this program is that it allows participation by people who may lack any financial resources to give on their own and empowers them to have a financial impact on the candidates they support. Now, HR 1 would also include a pilot voucher program to be implemented in 3 states in congressional races, allowing eligible recipients to receive $25 vouchers that could be given in $5 increments to candidates of their choice. And so that's all I have for tonight. It's some of the pressing problems we currently have, some potential solutions, and hopefully a better understanding of how we got here. And to close, I'd like to add that long-term, we need to reframe the conversation, both amongst ourselves and in the courts, about campaign finance. Since Buckley, courts have framed campaign finance regulation as always encroaching on or restricting speech. In other words, the perspective is always that these laws impede First Amendment rights, and that there must accordingly be a sufficiently strong reason to do so. But that relies on the false premise that the First Amendment only narrowly promotes the spending of money for elections and little else in this context. Instead, a more robust understanding of the First Amendment must include that the history and purpose of the freedoms it protects is to ensure democratic self-governance. Properly understood, campaign finance laws promote democratic self-governance and First Amendment rights, including by ensuring that our elected representatives are responsive to their constituents and not simply the wealthiest donors. Thank you very much. And like I said, I'd be happy to take questions in the Q&A.
Thank you, Mr. Llewellyn. We very much appreciate you providing this excellent foundation on something quite complicated and complex. And we appreciate you doing that as we move forward with our discussion. If you don't mind lingering, we will have our Q&A towards the end of our event. I want to remind attendees that we hope to have an opportunity to volley your questions, so that we ask that you please enter your questions in the chat feature. It is now my privilege to introduce to you former South Carolina State Senator, the Honorable Larry A. Martin. Senator Martin is a Republican and former member of both the South Carolina State House and Senate, representing the 2nd District, which is Pickens County, for 38 years, from 1979 to 2017. He was a leader in enacting tougher domestic violence laws, ethics reform, tort reform, stronger DUI laws, and more executive control of state agencies. Leaving the South Carolina legislature did not end Senator Martin's contributions to his community and his public engagement. He has served in numerous state and local capacities, frankly, far too many for us to mention, or we would be here until midnight. Just to mention a few, he continues his faith leadership with the Pickens First Baptist Church. He served as chairman of the Pickens County United Way. He's been the chairman of the Governor's School to Work Council, and on and on. And recently, we were very pleased with the League of Women Voters to announce that he will be serving on our state level advisory committee regarding redistricting. So we're very pleased to share that information with you. Senator Martin has firsthand experience, and I think illuminating real life insights into the impact of as to the impact of dark money in politics. Welcome, Senator Martin.
Thank you very much, Ms. Griffin. It's a real pleasure to be with the league this evening, the Charleston League, and of course, folks statewide. I have the Clemson League here in my backyard and enjoyed spending time with them over the years at various and sundry events. And I don't do this sort of thing very often anymore. And when you called and told me what it was about, it's a subject that's near and dear to my heart. I apologize. I've got an allergy problem, and I'm gonna have to drink some more water. Hopefully, I can. That may keep me from talking very long, but this is a subject very near and dear to my heart. And as I heard, Patrick in his presentation did a great job. It reminded me a lot, Patrick, a lot of those subcommittee meetings I've been in over the years when I would hear Buckley v. Vallejo and the McConnell case, and of course Citizens United. That was a biggie in more recent years that impacted our election ethics laws, and we would get a tutorial on those about every time. And you did a great job, and I appreciate it, and I know the group listening in appreciates it. You know, as long as we've had elections, there's going to be money spent vying for attention. And the key for the voter is to understand who it is that's attempting to influence them. And that's why we have disclosure requirements for candidates and committees to follow. We have contribution limits on candidates and candidate committees, but we don't have that in South Carolina on any of these independent groups, committees that spend money trying to influence an election. We had known this was a problem. Now, we had it years ago, Ms. Griffin. We had it back, I think, maybe when we enacted the major ethics reform bill back in the early 90s. We included independent committees, independent expenditures under the Ethics Act. And of course, what happened after Citizens United, there was a challenge made to that, and that provision failed pretty quickly based on the contribution limit. I mean, yeah, the contribution limit that was made or applied to the independent expenditure groups, and therefore we no longer had a disclosure requirement. And we got busy. Every 2-year session, we put the bill in to try to require disclosure, and we had no luck. It was just simply a situation where it got worse and worse. Every 2-year election cycle in South Carolina, we would see the results or the fruit of what was happening with independent expenditures being, or dark money being spent to influence elections. And we want to, do something about it. But unfortunately, opponents would argue, Patrick, that it was a free speech issue. And they would argue that, no, you're limiting our speech by doing that. A number of the groups that were engaging in that type of activity said, well, you're going to require us to disclose all our donors. And we don't want to do that. And, it might be a pro-life group or a religious group that didn't want to disclose their donors, and felt like that just by virtue of having engaged in some sort of election, tangential election activity, they would fall under the umbrella of the election disclosure requirements, and they would have to disclose all their donors. So we tried several different ways to address it, and unfortunately, the most significant opportunity we had was right before I left the legislature, when we enacted some pretty significant ethics reform in 2016, and restructured the Ethics Commission, brought complaints made on members of the legislature over to the Ethics Commission. We had the dark money disclosure in that bill. And what happened, I won't ever forget the discussion that we had trying to bring that bill to a close in a conference committee. And the word came forth very very resoundingly to the committee, the conferees that were working on the bill, that if it's in the bill, we're going to kill it. And we were running out of time, and they were very adamant to keep that out of that bill. And in order to get the major things that we felt that we could get, the restructured Ethics Commission, the complaints that were made on members of the legislature going to the Ethics Commission, ultimately we backed off and did not pursue it, with the idea that we would take it up the next session. But unfortunately, that never came about. And that election cycle, that I was in 2016, saw hundreds of thousands of dollars thrown in my very small county, basically a countywide election, or a little bit less than countywide election, because my Senate district did not include all of Pickens County. But just hundreds of thousands of dollars that were spent, to influence that election, and nobody had a clue where it was coming from. They bought a PO box. And it really wasn't a PO box. I'm trying to I'll describe it for you in a minute. It's one of these boxes that you buy, but it's in a UPS store or something like that, and that's where the box was. It wasn't in a post office box, and it was a local identified committee. It had a Pickens County connection to it, but the people that bought the box were not from around here, and they spent a lot of money. And some other members of the Senate at that time in that election cycle had experienced the same thing, and they had all said in unison that next session, where didn't matter if I came back or not, that was going to be a top priority. But unfortunately, it was not, because it never, so far as I know, and I stand to be corrected on this, I have not read the first newspaper article on any legislation coming up in a committee of the Senate until just recently. A bill was referred in the third 2-year election cycle since I left. Senate Bill 174 has finally been referred to a subcommittee, and it's getting a little bit of action, but it doesn't have a chance of passing this year because the session is all but over. So really nothing has been done, and I'm very disappointed by that. But South Carolina remains one of only 2 or 3 states. I don't know exactly where we stand. We refer to ourselves as being part of the old Wild West. Truly, with no disclosure, no nothing. I mean, it's so ripe for corruption. Part of the problem we run into is you got to get a bill pretty much in the hopper, get it acted on early in the session. And now with the session a little bit shorter than it used to be, you've got to get it moving pretty quickly in order to get it done in the first year of a 2-year session, and that's a hard lift. There are other ways to do it. Of course, you can do what we did in the ethics bill when we passed it. We made it effective the next year after the election cycle, because it's hard to pass something that becomes effective during an election cycle. So that's one of the other major problems that we've had over the years. But I will tell you that, and some of y'all may not know this, that the statewide grand jury actually spoke to this very issue a few years ago. You may recall there was a statewide grand jury impaneled former solicitor, or I think he's still the solicitor, but he's relinquished the independent counsel special prosecutor designation associated with what he was involved in, David Pascoe from Orangeburg, from that circuit. He of course dealt with several major ethics issues and brought them before the statewide grand jury, which thankfully we had amended the law several years earlier to allow that type of issue to be taken up in front of the statewide grand jury. And I had a couple of private conversations with him. I never appeared before the statewide grand jury. There was some discussion about my doing that, but he never invited me to actually appear. But we talked about it, and then when the grand jury report was released, and I'm trying to remember, I want to say it was about 18 months ago, or maybe 2 years ago now. He made sure to give me a call, and I read it. There was mention of my campaign in that statewide grand jury report, and the grand jury recommended that the legislature do its due diligence and rid South Carolina of this scourge of no requirements, disclosure requirements, or anything regarding dark money, and do something with due haste. And nothing has been done since. And it's just a real shame that we've had example after example after example of the abuses, not so much an election outcome like mine. I mean, I've long gotten over that, and I don't refer to it that way. But part of the intrinsic problem associated with dark money campaign is it's so there's no requirement those folks keep records. They're getting money from all different types of groups and individuals to influence an election, putting together a independent campaign, and there's no accounting for how they spend that money. There's no disclosure of it, who they're paying, how they're paying them. We had folks show up in Pickens County, walking, door to door with, and this was kind of new at the time, the phone apps that I didn't even know existed, that basically had the voter database loaded into it, and it wherever you were and turned that app on, it would show you the next house and who the voter was in that house and what their political leanings were. So you could either knock on the door or not knock on the door. And I mean, they had it down to a science, and they did a lot of legwork that way, and paid a lot of folks money to do it, but there's no accounting for it. And there was no disclosure of it, and nobody knows, how much was spent and who did the spending. So, we talk about free speech, and I would argue with my colleagues over that, yeah, I'm all for free speech, and I certainly want to abide by the Supreme Court's decisions in that regard. But folks don't have a right to hide behind these literally made up fake names of organizations that don't exist, and they're out there attempting to influence the outcome of an election, and they're doing a pretty good job of it. And as long as that continues, South Carolina will continue to be influenced, I think, in a very negative and adverse way in its public policy. And that's just totally unnecessary. If the public has an idea as to who it is trying to influence them, I think they'll make better decisions. And we can do that and stay within the ambit of the Supreme Court's decision. Just simply letting folks know who it is that's trying to influence them. I will tell you, Ms. Griffin, that Senator Campson, my old friend Chip Campson, is chairman of the subcommittee that just had that bill within the last 6 weeks referred to him, and I have every confidence he'll help get that bill through the Senate, hopefully early next session. And Senator Hutto's on it, and I know he's been in favor of it before, and some other members. But it doesn't go as far, Patrick, as I'm sure you would like to see in terms of a broad public policy. But if we just get something passed that would require disclosure, and the filing of the reports that so we can see where the money's coming from and how it's being spent, I think that would be a huge step in the right direction. As it is right now, there is nothing, and it's just very unfortunate that we're living in that environment. And unless and until the public in South Carolina really gets engaged on it, I don't know. I know good people like Senator Campson and some others will continue to make the effort to try to get it through, but there just seems to be a concerted effort down there to keep it in committee, keep it from being passed and acted, so that we can find out who it is that's trying to influence us. And I hope that that can change. The last thing I will say is I hadn't thought too much about the foreign influence issue that Patrick brought up, and I think that's something the legislature certainly needs to take it. We have a lot of foreign corporations in South Carolina. We accept, our candidates can accept we allow corporate contributions, but we require disclosure. But those same corporate entities, if they contribute money to a third party independent group, they're not required to report that. There's no reporting of it. And we could have foreign influence attempting to do that, and in a statewide race like a governor's race, an attorney general race, or something like that, that could be very significant, affecting the outcome of an election by a foreign foreign-owned corporation. So I think that needs to be addressed by the legislature as well. But having said that, I'll sort of wind up my comments and, like Patrick, attempt to answer any questions you might have.
Well, you're not getting off the hook quite that easily. We're going to ask both of you to linger just a little while longer. We want to share our call to action, and then we will move to questions. I really want to thank you, Senator Martin, because on top of the foundation and information that Mr. Llewellyn provided us, there is that other layer of the reality of political life, and your insights are very, very helpful, because that's just another level of complexity that all states have to deal with. We're now going to move to our call to action, and that will be followed by an opportunity for questions and answers. I want to first remind you that I said earlier that we have had a call to action associated with each of our events. And for those of you who were able to attend our first event, it was on voting rights. And of course, the subject of the For the People Act certainly came up and was an action item. I was advised this morning, we knew that, of course, that the House had passed their bill quite some time ago, and it was pending Senate action. I was advised this morning, and you all may have more recent information, but the Senate plans to move to mark up S1, which is the Senate's version of the For the People Act, tomorrow, May 11th. So those of you who wish to express an opinion to your U.S. senators, time is of the essence. But now I want to move on to our call to action for this evening. And I'm going to ask Leslie Scarden to lead us in this effort. I think it will be interesting, and I hope it has a longer term shelf life value to all of you. Leslie.
Great, thanks, Barbara. So we're excited about this call to action because it's a bit different from our other ones. As Barbara mentioned, we've talked about supporting legislation. We've done an exercise for redistricting around communities of interest. We've asked you to read the pre-reads and ask your state reps about certain issues, if they support them or not. This one, we're going to do a brief tutorial and how to look up where your state reps get their campaign contributions from. So very timely to this event. So I'm going to go through this and then we will send this out. So this will be in the follow-up email that you'll receive. So if you're not following or you're writing down links, don't worry, you will get this. And just for the sake of time, I'm going to move a little quickly because I want to make sure that the Senator and Patrick get to answer your questions. So step one, let's find your legislators. This is the website. You can go to scstatehouse.gov or more easily just type into Google, find my legislator, South Carolina. You'll come up to this page. You'll be able to write in your address here, and then you'll find who represents you at a state and local level. So once you know that person, let's say it's John Smith, we want to find out who gave money to John Smith in this past election. So you are going to go to ethics.sc.gov. This is the South Carolina State Ethics Commission website. And there is actually a treasure trove of information that you can find here. It can be a little intimidating to navigate. So we're just going to go through one piece of what this website can do tonight. So at the top of this web page, you'll see a button right up here that says public reporting, and you're going to click on it. And then when you get to public reporting, there are a couple of different buttons you can click. For the purposes of this discussion, we're going to look up individual financial reports. So, let's say my state senator is John Smith. I want to see who gave John Smith money. So I'm going to click on individual financial reports. Then it's going to take me to candidate reports. So just a weird little extra step right here. We can't talk about statement of economic interest. That's essentially all the disclosures a candidate has to make so you can see where they work, where they get their money from. But for the purposes of this, we're just interested in who is giving them money. So you'd click on candidate reports. And then you'd search their last name here. So you type in their last name and you're going to have a couple of different things come up because if I type in Smith, there are going to be a lot of Smiths that pop up in South Carolina. So you're then going to be taken to a new page that lists all the Smiths out there. So what I typically do is I would then do a quick find for John Smith, and it would take me to the list that says John Smith, and I would see his name. I would see the office, state senate, and then I'd see a bunch of dates. So if we wanted to find out the last election, I would click on the report that has November 3rd, 2022. And I didn't do this for a real candidate because I didn't want to single anyone out. So that's why I'm not showing you the full list. But once you type in that name, then you scroll down and you find the person and the race and the date. Then you're going to get this bar right here. And this is interesting. You can see a summary of how much money they got in a quarter, how much they spent. You can see loans that are made, loans that they've paid. You can see what they've spent all their money on, right? So how many mailers they've bought or digital ads they've purchased or yard signs. But what we're interested in is the contributions. So you click on contributions, and then you're going to get a really long list of everyone who has given them money. You will see individuals who have given to them. You'll see addresses. You will see occupations. And you'll also see some potential LLCs or PACs. So this is what's interesting to look for. And we've just chosen a couple of very random, diverse institutions here. So if someone had a donation from a PAC, PAC, that'd be interesting, right? Or if there's political in the name like this, or Paul Action Fund, those are all different types of ways of signifying that it's a political action committee. And we know that there are differences between that and dark money, but it's interesting to see which of these organizations are giving to candidates. Now, again, there's a lot of diversity within these PACs. So the Low Country Livability PAC, for example, is a group in Charleston that works on infrastructure planning and resiliency. They donate to local city council races. So this wouldn't be in John Smith's disclosure, but you might see it in another. The NAIFA PAC is a group of insurance and financial advisors in South Carolina. So whereas Low Country Livability is really focused on Charleston, this NAIFA PAC is statewide. Then you might see some random things like this SCBWA Political Action Fund, which is actually the State College Borough Water Authority in Pennsylvania. So a very weird organization to be giving to a South Carolina race. So you can Google these. Sometimes you'll find information on them, sometimes you won't, but it's really interesting to see who might be trying to influence or support that particular candidate so you can learn more. So that is a very brief overview. Again, we'll send out this information. We would encourage you to look up your legislators, see where they get their money from. And if you have a question, ask them about it.
Thank you, Leslie. We have about 15, maybe 20 minutes for questions that have been submitted by you. I have a few questions, but let's begin with asking Shana Howe to share the questions that were submitted in chat. Shana?
Hi. Give me just a second, and I'm going to pull up a couple of the questions. We have several in chat. Okay, so following along with the call to action piece, Mr. Martin, you spoke about the Senate bill, this one opportunity to sort of take action, and the league being action oriented as we are, we have a couple of league members asking questions about, how do we shine more of a light on dark money? Obviously, it's a very complicated issue. Senator Martin, could you please just is it Bill S-174? And if you could just talk quickly about that bill. I know the league is in support of it and has given testimony, but if you have a little bit of background on that, and if we think it's going to come back up potentially when the new session starts in January, maybe we can take action on it.
Well, be happy to. It was pre-filed this past session, means it was ready to go as soon as the filing started, and then it was referred to the Judiciary Committee, and then it was only referred to a subcommittee though, and this is where some action gets taken on it on March the 11th. So halfway through the session, it finally got a referral to the subcommittee. Now I will say that it has some significant authorship. It's a bill. The bill primary sponsor is Senator Bennett from there in the Low Country, Senator Leatherman, Senator Hembry from over in the Horry area, and Senator Rankin from the Horry area, and he's chairman of the Judiciary Committee. But the bill essentially, without getting into any great detail, it requires that any election committee or communication that's intended to influence the outcome of the election. And of course, as Patrick pointed out, that it uses those magic words to oppose clearly, to support or oppose a clearly identified candidate or ballot measure. They would have to disclose just as a candidate would have to do, their expenditures and their contributions. And it would give rise to a more detailed understanding as to who they are. So independent expenditure committee, independent expenditure, again, you can't put limits on it, and in terms of how they spend their money. You can't limit, now South Carolina at state level, state legislative race, for instance, each candidate is in an election cycle. There's a limit of $1,000 per election cycle per contributor that is limited by statute, and that's permissible. But under the court's decisions, and that's what triggered our law's failure back 15 years ago, you can't put limits on these independent expenditures. You can't put a contribution limit on them, and that's where our law, that was a defect that killed our law originally. So there is no limit placed on it because you can't, but you can require disclosure, and it's just so vitally important. I think the legislature, what I would urge the members to do in terms of talking to the legislature or communicating with them about the significance of it, is that we simply want to know who it is that's trying to influence us, and we want you to conform to the Supreme Court decision, and the law have some meaning and be enforceable. You can't put limits on it, but you do have the obligation, I think, to act and let us know who it is attempting to influence our election. As it stands right now, a foreign interest, for instance, could attempt to influence our election in a very deleterious type of way, particularly a governor's race or a attorney general's race. There's no requirement. They would be violating no state South Carolina law to do that. So at a bare minimum, we need the disclosure. Even if you don't ban that foreign interest, we need the disclosure to know who it is that's trying to influence us.
Thank you. And that's S-174, correct? We have a couple of people just checking Senate Bill 174. Okay, we're going to go to another question, which we didn't discuss this directly in the meeting, but it is an interesting question. Maybe one of you can answer it. If a candidate has announced a run and is fundraising for a position, accepting contributions, and then doesn't run, what is allowed to happen with those funds?
Well, in South Carolina, every state's a little different in that regard. Unused or unspent funds that were raised by a candidate can only be disposed of in a certain way. You either return the contributions on a pro rata basis. Say you spent 50 cents on every dollar that was raised, and you decided, I'm no longer going to be a candidate, I want to close out my campaign account. You got to dispose of it by giving it back to the folks that contributed it to you on a pro rata basis, or you can contribute it to the state's general fund, or you can give it to a nonprofit group that doesn't have anything to do with elections. For instance, you could give it to the United Way, or you could give it to or you could give it to a church. But you have to disclose that. how you disposed of it, and you only be disposed of in that fashion.
Is that a pretty typical way things are done, Mr. Llewellyn? Is that something we see across other states as well?
Well, I think as Senator Martin said, it does vary from place to place what the exact rules are. And it sounds like this is not a problem in South Carolina, but in some places there have been problems where the law is not clear on restricting, for example, campaign funds being used for personal use. So sometimes you'll have problems with politicians, in particular in that situation where maybe they've wound down their campaign or have decided not to run for re-election if there's not close restrictions, using those funds as sort of like a personal slush fund to personally benefit themselves. So it's good to hear that that is not allowed for under South Carolina law, because that's usually something that we advocate for, is making sure there's strict restrictions on not allowing candidates to use campaign funds for those purposes.
Right. And this next question, Mr. Llewellyn, I'll ask you to tackle first. We've heard pretty clearly that South Carolina is well behind other states in their ethics laws, and hopefully we can move that forward a bit. In states that have strong campaign finance and ethics laws, what would you point to as the positive impacts on that for voters, specifically for the democratic process, the elections in that state? What would you list as sort of the top impacts of that?
Well, I think there's a couple of things. At a high level, and I know that South Carolina does have some of this in place, but ensuring that there's a good system of contribution limits, for money given directly to candidates, given to parties, or given to political committees that then give that money to candidates, including having, for example, direct corporate contribution bans. It gives voters confidence that their elections are not for sale, that there is some protection against corruption in the democratic process. And then as well, when it comes to disclosure, I think as Senator Martin already has mentioned a couple of times as well, it helps voters have the information that they're entitled to know who it is that's trying to influence their vote. And so it helps them to properly understand, when they see these electoral ads saying vote for or against this candidate and the reasons why, they're able to understand better, who it is that's running that ad and why they are trying to get them to vote that way. And so I think it's about providing, it gives the voters a sense of that they have more control and more understanding of what's happening in the election because they have full information.
I would only add to that we have been fortunate in South Carolina that when things have been brought to light, we've either addressed them or some action was taken. I'll point back to that grand jury and Solicitor Pasco. It's a matter of enforcement. There were things uncovered that provided a roadmap for the legislature to act further, particularly on dark money. But there was also prosecutions made under existing ethics laws that had been violated. When that was found during the course of that investigation, charges were brought. There were several members, if you recall, several members of the Senate, or a couple members of the Senate, one member of the Senate and the House that, and a former member of the House that were brought into that, and they were dealt with. And the key to it, South Carolina is still somewhat of a small state, and that was one of the huge reasons that I worked so hard to get the complaint process brought over to the State Ethics Commission would involve members of the legislature, particularly something of any significance that needed to be dealt with. That ethics law matter question needed to be dealt with by an independent fact-finding group as opposed to the legislature's ethics committees dealing with it. And because we had seen that had been a problem, and things had been allowed to fester and go on that got into being a bigger problem with some certain members. And we recognize that for what it was. So yeah, it's real interesting. We've got some good law in South Carolina. It's got to be enforced.
Well, Shana, thank you for leading us in our question and answer period. We wish we had more time, but we do make a promise to our attendees that we will begin on time and try to end as close as possible. We absolutely want to thank Patrick Llewellyn and Senator Martin for their insights, that foundational information that is so critical to us understanding what is, after all, pretty complex set of issues with which we are all about which we are all concerned. I want to thank our team and particularly Leslie for sharing with us our call to action and Shana for marshaling our questions. I want to invite you again to join us for our final good governance event on June 7th that will focus on voting systems and options. We also hope you will explore this evening's call to action option that Leslie walked us through. It may help you personally feel like you understand better about the candidates that represent you. And we want to thank you all for your attendance and for joining us, and good night.
Good night.
Thank you.
Thank
Thank
you.
Thank you. Bye-bye.
Bye.